Hey everyone, welcome to This Explainer. Man, if you've been glued to the news lately, just watching the chaotic state of the world is really easy to feel like the rules that are supposed to govern us are just completely falling apart, right? Today, we are going to dive headfirst into this widely debated enforcement crisis of international law. We're going to figure out if the system is literally failing or if it's just profoundly misunderstood. We're going to look past those terrifying headlines and map out exactly how international law is actually designed to work. Okay, let's jump right into it. When you look at this timeline of recent headlines, honestly, it's incredibly easy to see why so many people assume international institutions are totally toothless. I mean, think about it. You've got China rejecting the South China Sea arbitration back in 2016. Then Myanmar just completely disregarding the International Court of Justice on the Rohingya crisis in 2020. And lately, we're seeing unexecuted ICC warrants against sitting leaders like Vladimir Putin and Benjamin Netanyahu, alongside a UN Security Council that seems completely paralyzed over Gaza. Seeing all these instances of broken rules back to back, it paints a pretty bleak picture, doesn't it?
So, with so many massive state actors seemingly getting away with blatant defiance, we really have to ask a blunt but totally necessary question. Is international law actually dying? Like, is the whole system just collapsing in on itself?
To crack this puzzle, this explainer is going to objectively map out the architecture of international law across 6 key areas. We've got the enforcement crisis, what makes a law, anatomy of paralysis, why states comply, the true power of courts, and finally, structural limits versus decline. Let's get to it.
Section 1. The enforcement crisis. A system in decline or structural exposure. Let's start by unpacking what legal scholars actually mean when they talk about this quote-unquote crisis.
The absolutely crucial point we're going to uncover here is this. The foundation of the law itself, the core structure, is actually fully intact. The crisis we're witnessing, it's strictly an enforcement issue. These failures to stop global conflicts, they definitely expose the system's structural limits when it comes to physically forcing states to do things, but, and this is a big but, they do not mean the law itself has crumbled, or even that it's lost its legitimacy. It's a very specific type of failure that we need to correctly identify.
Moving to Section 2, what makes a law? Dismantling the myth. To really grasp this distinction, we need to completely redefine our basic assumption of what makes a law, well, a law.
Notice how we can break down the concept of law into 3 totally distinct pillars, or axes. First up, existence, or validity. Basically, does a rule qualify as a law based on a treaty or a custom? Second, legitimacy. Is it fair, and do states actually accept it as a standard of behavior? And third, enforceability, which are the actual mechanisms used to compel compliance. We really have to pull law apart into these 3 pillars because, even if the gears of enforceability grind to a complete halt, those first 2 pillars remain entirely intact and valid. The law definitely still exists.
This comparison brilliantly illustrates the core issue here. Think about how we view law in our own daily lives. Domestic law is basically a hierarchical pyramid, right? It's backed by a centralized police force sitting right at the top. If you break a law, an officer can literally show up and physically arrest you. But international law, it is completely different. It's a horizontal, consent-based system that prioritizes sovereign equality. Let me repeat that. There is no global police force. None. So expecting international law to act like domestic criminal law is just a massive category error. We're judging a system built on consent by the standards of a system built on coercion.
Section 3. Anatomy of institutional paralysis. Mapping the gridlock. Let's look at the specific institutions to see exactly why they appear so utterly paralyzed during current global conflicts.
So the gridlock we're seeing, it's actually a feature of institutional design choices that were made literally decades ago. Take the UN Security Council, for example. The paralysis over Gaza and Ukraine isn't some failure of international humanitarian law itself. It's a direct result of Article 27. That's the veto power granted to 5 permanent member states way back in 1945. Next, look at the ICJ. In cases involving Myanmar or Israel, the court can issue provisional measures, sure, but under the UN Charter, it relies entirely on the Security Council for enforcement, which, you guessed it, leads us right back to that veto power. And finally, the ICC. It issues warrants for major figures like Putin or Netanyahu, but it doesn't have its own police force, and it operates without universal ratification from major global powers. The rules underlying these institutions are completely valid. It's just the enforcement architecture that was built with these very specific bottlenecks.
To really wrap our heads around this, we need to look at what legal scholars call the yes-but precedent. Like a gavel striking an anvil and taking root in the ground, sometimes rulings establish incredibly deep foundations, even if they hit an immediate brick wall of enforcement. Back in 1986, the ICJ actually ruled against the United States in a super famous case involving Nicaragua. And yes, the US totally refused to comply. Yes, the US used its UN veto to block enforcement. But despite that total lack of enforcement, that ruling still permanently shaped the authoritative rules of global behavior. I mean, it remains a foundational precedent that gets cited in virtually every single use of force dispute today. The law's normative authority completely endured, even when immediate enforcement failed.
Section 4. Why states actually comply. The unseen engine. Okay, so if there's no global sheriff to force compliance, and powerful states can just throw around vetoes, why on earth does any state ever obey these rules?
Well, this famous observation by legal scholar Louis Henkin provides a really powerful counterweight to our totally doom and gloom news cycle. He noted that almost all nations observe almost all principles of international law almost all of the time. We naturally focus on the dramatic, flashy violations, but we completely ignore the unseen engine. Every single day, international mail gets delivered, and thousands of airplanes safely cross sovereign borders. Why? Because of treaties that work perfectly without any global police force. It's a great reminder that global coordination relies heavily on voluntary compliance and diplomatic reciprocity, not just the threat of physical force.
Let's break down the actual theories of why states comply without a gun to their head. First up is the managerial model. This basically suggests that a lot of non-compliance isn't some cynical, villainous defiance. It's often just a lack of capacity or a misunderstanding of ambiguous rules, stuff that can easily be fixed just by talking it out. Second is the transnational legal process, which is this idea that international norms slowly, gradually seep down and get internalized right into domestic legal systems. And finally, constructivism. States actually care deeply about their reputations. They want to be seen as legitimate, rule-abiding members of international society. Notice that even when powerful states do break the rules, they almost never say, oh, international law doesn't exist. Nope. Instead, they offer these incredibly complex legal justifications, like claiming collective self-defense. So even in violation, they're using the vocabulary of the law, which implicitly acknowledges that the law actually binds them. Fascinating, right?
Section 5. The true power of courts. Working without a police force. So what exactly is the practical day-to-day power of international courts if they can't, send in the troops?
Here's the secret. Judicial institutions substitute coercive enforcement with normative enforcement. They essentially have 5 main functions. First, norm clarification. Think of how the Chagos advisory opinion totally reshaped state practice around decolonization. Second, legitimation and delegitimation. When a court ruled against China's maritime claims, they didn't physically stop Chinese ships, right? But it delegitimized the claim, forcing them to bear massive diplomatic cost. Third is fact-finding. Courts create an authoritative, trusted record that other nations rely on. Fourth is complementarity, which basically means international courts encourage domestic courts to step up and prosecute crimes themselves. And fifth, their rulings trigger decentralized reputational and economic consequences. To put it simply, courts don't need a police force because they arm third-party states and NGOs with the authoritative facts they need to legally justify their own economic sanctions or diplomatic isolation. They provide the legal ammunition for everyone else to act.
Section 6. Structural limits, not decline. Reframing the crisis. All right, let's pull this all together and totally reframe how we should be viewing this ongoing crisis.
Now, to be clear, we absolutely should not ignore the genuine cracks in the system. There are some very real dangers here. Selective enforcement, where powerful states escape accountability while weaker states get hit with sanctions, that severely erodes the legitimacy of the whole system over time. We also have to worry about repeated, high-profile defiance by UN Security Council permanent members, because if they break the rules too often, it kind of normalizes non-compliance for everybody else. And finally, there's the very real risk of fragmentation, where the global legal order splinters into competing, localized regional regimes. These are very real structural gaps, and they deserve our honest attention.
But here's the thing. To declare the system completely dead, we'd need to see true systemic decline. We would literally need to see states abandoning multilateral treaties altogether, denying that rules against things like genocide even exist, and retreating entirely into the realm of raw, unhinged power politics. But look at the actual evidence. Wholesale repudiation is simply not happening. States still overwhelmingly frame their conduct, however self-servingly, in the language of international law. The fundamental existence and legitimacy of the system, they actually remain remarkably intact.
So, I'm going to leave you with this final somewhat provocative thought. If international law was designed from the very beginning to coordinate equal sovereign nations rather than act as some overarching global police force, is the current crisis really a failure of the law itself, or is it simply a failure of our expectations of what it was built to do? Instead of mourning the death of a global police force that, quite frankly, never actually existed in the first place, maybe it's time we honestly confront how to reform the enforcement architecture we actually have. Things like rethinking the UN veto or expanding universal jurisdiction, just to ensure the rules we all depend on actually continue to hold weight. Thank you so much for joining me on this explainer. Keep questioning and keep learning.